Welcome to the program. I'm joined by my friend, my colleague, Alan Gassman. Um, we're going to cover 5 topics that we picked that we think are of interest or should be of interest to anyone and everyone in estate planning, frankly, no matter what discipline you're in, whether accountant, attorney, wealth advisor, insurance consultant. And we're going to cover disparate, sometimes unrelated topics just because they're things that we kind of either think are interesting for you with AI, because I think people are not using it nearly enough, and there's really interesting stuff that could be done. We're going to talk about some things that we see going on in the estate planning world and a recent development. Um, and this is a little impromptu, which hopefully will keep it easy and interesting to listen to. Alan, I don't have the case in front of me, but there was recently a follow-up on what I thought was a pretty important and interesting asset protection trust case. In Delaware, uh, there was a case, and I'm sure we lectured on it or did an
Yeah.
article on it, something like CES Trust 2007 or something. And the Delaware court upheld a Delaware Domestic Asset Protection Trust, or ADAPT. And I think that's one of the few cases upholding ADAPT. And clear from the facts in the case, the defendant who had settled the trust was not pristine in his trust administration or anything else. Nonetheless, the court upheld the trust, which I thought was very important to know for all of us in doing asset protection trusts. And we have separate lectures and articles about that, drawing all the lessons. There's a recent development from that case where a Colorado court ruled against the defendant. You want to explain what that was about, and then after you explain, we'll talk about it. But most important, we can go back to, does that have any impact on the meaning import of the Delaware court upholding the DAPT?
Yeah, my understanding is this court was not very pleased with his conduct, and he had been ordered to do certain things, and instead he did certain other things. But basically, he committed what we call a voidable transfer,
Fraudulent
also
conveyance.
known as a fraudulent conveyance. And not necessarily that he committed fraud, but he made a transfer for the purpose of avoiding a creditor relating to an LLC that was probably under this trust. So while you have a valid trust, the trust may become a defendant in a fraudulent transfer action, and the trustee of that trust may have to put some assets back into the uh, hands of a creditor, notwithstanding that the trust is and has been found to be a valid trust.
So this bad transaction he did, assuming the LLC is owned by the trust, and I'm not sure if it is. I searched the name of the trust in the case, and the plaintiff, I didn't see it come up in the recent case, but that doesn't invalidate the trust. It invalidates or forces a give back of that one asset that was improperly handled.
That's right.
I think one of the and it seems every case, like the small Dino case on step transaction, it, so often the cases that we get are not bad facts, they're awful facts. So the defendant in this case that we're talking about, there was a court in Michigan that said in a ruling, thou shalt not transfer any asset outside of the normal course of business. I mean, it's pretty clear what that means. And he transferred a property worth, I think, almost $1 million. I don't recall if there's a mortgage or not on it, for $10. I mean, you can't violate common sense like, hey, you're bankrupt, why are you making a transfer? You can't violate a very clear and understandable and reasonable court order and expect to come out clean. So I don't think that negates anything that we've said previously about the positive holding in the Delaware case upholding the trust. I think what it reiterates is a lesson that we all try to educate clients about, not often as successfully as we want, like this case. You got to come back for periodic reviews. You got to talk to your whole professional advisory team. Yes, you actually have to spend a few dollars on your lawyers and accountants and maybe even the wealth advisors so everybody can help you administer your plan. I find too many clients are wanting to be one and done. I signed the trust, I'm done. And then you never hear from them. Comments, thoughts, lessons.
Well, this type of conduct is as old as history, trying to avoid creditors by moving assets. And in most states, the only uh, remedy is attorney's fees, costs, and trying to get the asset back. He may have delayed these creditors a decade. I don't know how long, he's gotten away with this. And, maybe he was hopeful that he'd be able to recover and pay everybody or never intended to pay anyone. Depending upon what state this occurred in, the lawyers who helped him may have culpability. There's been a Florida court have said that a lawyer doesn't have culpability helping somebody make a transfer to avoid a creditor as long as they didn't break any laws or commit actual uh, fraud or dishonesty. But different states have different rules, so you have to be careful. In Connecticut or California, this could get you disbarred. So everybody be careful out there.
Yeah, there was a case that Jonathan spoke about years ago in a webinar we did on asset protection. I'm thinking Idaho, but I may be wrong, where a lawyer was really disciplined severely. It may have been worse than disciplined for participating in a transfer that was a fraudulent conveyance. Um, so, let's segue because I think this is really important into something that you can demonstrate that I think is something not enough people do and I was fascinated by it. And that's how you can use a State Views AI module to get background on a client while you bring it up, and you can use me or you as an example. But if something bad comes up on me, don't show it on the screen. Um,
Good stuff
so
there on you.
it's important if you do due diligence on new prospective clients, and I think we all should do due diligence on clients, that you do it uniformly. You don't want to find that you only do due diligence on certain clients and find yourself facing some kind of claim that you've been discriminatory or whatever. So you should make it a standard in your practice. It is so common in estate planning for clients to make transfers. Even just setting up an LLC and putting assets into it can make it more difficult for creditors to reach. Certainly, all the irrevocable trusts we create, whether it's for asset protection, estate planning. Now we're doing lots of non-grantor trusts for income tax planning. If they're irrevocable trusts, complete a gift trust, you've moved assets. So I think what Alan's going to demonstrate, and I'll let you do most of the talking, Alan, is an incredibly powerful tool. Alan, how long does it take to do a search on somebody?
Probably 5 minutes. We'll see here. There's one started.
So 5 minutes of time, which an admin person can do to get a report on somebody, Alan has not added, but based on my asking and encouraging, is going to have a button on the side for a summary or maybe make it automatic to identify bad stuff. So if you have a prospective client, you could just do a Google search, but wait till you see the power of what Alan's going to demonstrate. I think this is something that everyone should consider doing for every prospective client, no exceptions. So no one can accuse you of discriminating in who you apply this to. And if you come up with things that are an issue, you really, really need to ask this prospect before they become a client. Um, I've done webinars. There's a recording of one on the website, firm website, on terminating clients. And there have been lectures at different institutes about it. And one of the things is really clear and really simple. If you terminate somebody before they become a client, you have no fiduciary obligation, no responsibility as an attorney or any professional to that person. They're not yet a client. After somebody becomes a client, at that instant in time they become a client, now you have to start looking at ethics rules and requirements, obligations, and any harm you may cause the client. So doing a due diligence search and then asking uh, questions if need be can help you be careful in who you hire as a client. Alan, I'm going to let you talk, but I think this is a really powerful thing everybody should think about doing, every firm.
Yeah. So, you can do a Nexus Lexis search and they'll search, or you can do a detective search for usually $100 and they will search the public records and they will tell you certain things. But the internet turns out to be more powerful. And if you have 25 to do sophisticated Google searches, you can, but instead you can ask artificial intelligence to go through a certain routine including going to the Wayback Machine, because when you search Google, you're searching what's on the web now. But if you go to the Wayback Machine, you can search every 3 years going back 10 or 15 years. So what our programmers did was they programmed in the software this hierarchy that you see of the different searches that are going on, both in real time and the Wayback Machine. And
Alan,
yes,
I think you should just take a second and explain the way back concept because some people may think it's a Grateful Dead song.
it probably is a Grateful Dead song, and we should talk about that too. But the Wayback Machine, I don't even understand what it is, but it's a way in the internet that you can see exactly what was on the internet at a certain day and a certain time. So when I'm looking at somebody's website and they entered into a transaction with my client in 2018, I can look and see what that website said on that day in 2018 when they were talking to my client. And that becomes very valuable when you have somebody who's been doing things that are questionable. They've hit them, but they were on there before.
So if somebody sanitizes somehow entries, this approach may find them.
That's right. That's right. Exactly. So, and we find, when you run the Nexus Lexis search, you run a detective background search, they'll find a bankruptcy. They will, and they'll find arrests, but they're very sterile. Like I was looking at a land developer last week for a client, and it said he had a bankruptcy in the detective report. I knew that, but then the Wayback Machine found me that he was accused of fraud, and he made the newspapers by defrauding investors allegedly. And then he didn't get his discharge from bankruptcy because the bank found that he had committed a fraudulent transfer within 1 year of filing it. I wouldn't have gotten that from the detective report or the LexisNexis report. It just wasn't in there. So
And
I
Alan,
miss
that
it.
took, how much time did that take? What did that cost you to generate that critical information?
Well, you just saw what I just did for you. It took as long as we've been talking here. What, three to 4 minutes?
Nothing. And the
No,
cost, incremental cost,
yeah, well, nothing.
peanuts.
Yeah. I mean, we don't charge our subscribers to use this. It's just part of the subscription. But then what did it also do, Marty? It also prepared a CV for you, which you could compare to your CV. And it wrote a nomination letter to nominate you for the recognition and best lawyers, which you're already in, I'm sure. But isn't that pretty interesting? I mean, now the other thing I wanted to show you is, we all worry about hallucination. So our solution for that is we have a button here called review.
Alan, I'm going to interrupt.
Yeah,
Define again, just like way back, define hallucination so people understand. We're not talking about psilocybin.
right. Well, that goes back to the Grateful Dead concert, doesn't it? So, um, AI will occasionally make stuff up that's not true. Nobody knows why, but even the best AI generators will make stuff up that's not true. And when you're a lawyer and you're looking at something, you typically know it's not true and you ask it to correct it and it will correct itself. But the better solution is that I've created everything that you see here using a Google Gemini, which I really like. But I can now have OpenAI ChatGPT 4.1 review it all. So now I have OpenAI ChatGPT 4.1 reviewing everything that we just did. And then I can push another button and it will rewrite it based upon the combined contributions of of both AI.
Can this comparative, the second AI that you're using, can it identify so you know what might have been mistaken?
Yes. Yep. It will go through and tell you exactly what the problem was. And then it'll regenerate the whole thing. Uh, and that should uncover any hallucinations. I mean, it's not 100%, but I would say it's got to be go from 98% accuracy to 99.5%
Yeah,
accurate.
we don't really know how to gauge the accuracy, but the power of this to me is absolutely incredible. If for no cost and in 5 minutes or less of time, a prospective client can be vetted objectively, and I can do it for every client. And once Alan gets installed, which I hope you do soon, Alan, a summary of worrisome issues, I don't know what you'll call it, red flag report, where you have anything that has to do with um, uh, falsehoods, fraudulent transactions, bankruptcies, criminal records, just a summary of key highlights. You can make a pretty quick decision as to whether or not you have more questions to ask a prospective client, or it's in some instances you may simply decide not to accept that client, that prospect as a client. And like I said earlier, there's no ethical obligations if you get out before the person becomes a client. And even if you have an existing client that's returning that you haven't seen in 10 or 20 years, a lot of stuff can happen in 20 years. And then Alan, and I thought this was incredibly brilliant what you did. I don't know if it was your idea, but I'll give you credit for it. To have a second AI system check it. If there's errors between the two, you got to be pretty close to being accurate. And listen, if the prospective client or a returning client that was like a dormant or inactive client explains this stuff away that comes up, and you may decide to take them. But if you're not comfortable, you don't reopen a new file. You don't accept the prospect. I think this is absolutely something that we all, Alan, why is everybody not going to do this? I mean, it just seems to be so logical.
They should, and the clients enjoy receiving them. When we get a new client, we say, "Here's a report that we just got on you," and they like, "Wow, look at all these things I did. I forgot all about it. This is very neat. I didn't know you
If,
went to Wharton, Marty. That's pretty impressive."
yeah, the standards were lower back then. Um, but I think this is an incredible concept, and you can use it in different contexts. So, for example, I stopped keeping track of a CV for myself years ago. Alan, you'll email me this. I'll have a current CV.
Right.
I think if you're questioning a witness and you can get this kind of detail, the issues that are coming up could be huge. Vetting new clients, returning clients. Alan gave another example that I thought was fascinating. And it's not really what a client even comes to us to do, but I think Alan must have really been the shining star for this client, where the client was doing a business deal and just he checked out the partner to be in the business deal and found some really worrisome stuff. And I mean this wholeheartedly as a vegetarian. He saved the client's bacon.
Yeah.
So that I mean and I'm sure if we thought about it, Alan, there'll be other applications of this. But to me, this is very powerful and something we should all be doing. Any other comments on it or thoughts to share?
No. No, I mean, I think that covers it. It's just something you can do while you're on the phone with the client or while you're even on a Zoom call with the client, checking these things out, people they're dealing with, and learning about their situations instantly and at almost no cost.
Alan, let me ask you a question because some people may feel that well, gee, I can just, Google search John Smith's name. You had programmers create the questions that AI is looking for to get a much more thorough analysis than me just putting John Doe's name into Google, correct?
That's right. That's right. I mean, even if you have Chat GPT 4.1 or Perplexity, you would have to ask about 15 questions or more to get this information. So it's really about setting up the protocols. And you can teach your AI bot these protocols, but why bother? We already did it for you. And, and when
That's the power of what you're getting when you buy a system that does all this. That's very important. You don't have to think of it. And Alan has been tinkering with this, and he didn't think of having a summary button of red flags that I told him when he first showed me how powerful this was. I thought it was incredible for the applications we've talked about. When he gets that red flag button, um, I'm going to vet every prospective client and every returning client. Why not? And by the way, Alan, I didn't even think of this till now. If I have a client that hasn't been back in 10 or 20 years, and we all have lots of clients we did wills for, in the Stone Age, and but they finally show back up. If you do this, you can actually see what's going on in their life in the last 20 years to start before you start the conversation.
And what's the most important person thing to someone? The first thing is their name, and the second thing is their information. They want to talk about it.
Right. Everyone likes to talk about
Yeah.
themselves.
I forgot that Jonathan was a captain in the U.S. Army. I forgot he's a pilot, a hunting and a fishing guide. That type of thing is important to the person you're working with.
So let's change gears, Alan. I think we could just go to big close the screen for a second if you can do that. Just have our handsome faces. I don't think anyone's buying that. So one of the things, and I don't want to belabor this because we need to do a whole webinar on it. And I got an article in process with Jonathan, so we'll corral him into doing a webinar. But I think I'm hearing so much about it. It's important to talk about. So I'm getting a lot of questions from clients, financial advisors, not so much from other attorneys, but well, gee, shouldn't we terminate this irrevocable trust so the assets get back in the estate and get a basis step up? And I'll just give you one example, and we can limit it to that. But I think it's important people think before they jump. Um, so dad dies, sets up a credit shelter trust with mom with a couple $1 million in it. This is when the exemption was like $2 million. Now the exemption is $15 million. And somebody says, well, gee, let's just terminate the credit shelter trust and give all the money to mom so that the NVIDIA stock will get a basis step up. Is it that simple? Is it that safe?
It's certainly not safe if there's a remainder interest beneficiaries who are going to complain later and their descendants going down generations. So people forget all about the fiduciary aspects of this. And I was a witness in a case where a lawyer followed the state law perfectly and was able to eliminate and change a trust following state law. But the beneficiary still sued him, saying there was a deeper fiduciary duty, deeper than what the state law allows. So you really have to be careful. And the safest thing to do is to go to court, file an action, get an ad litem appointed to represent minor and unborn heirs, and set aside a certain portion for them equal to the present fair market value of their interest, and pull the rest out, but keep that in just for the minor and unborn heirs. That might be one example of what you could do. The alternative is keep it all in the trust, but give a power of appointment to somebody, and maybe not to the grantor of the trust, maybe somebody older and feebler who's going to die earlier to get you to step up earlier where it stays in the trust. So all those things have to be considered.
How do you feel about adding a general power of appointment to an existing trust that didn't have one?
I I don't see a problem with it. I mean, eventually somebody's going to, you know, eventually the IRS is going to have issues with these. It doesn't seem to be on their radar yet. But if the power is not exercised in a way that does damage to any beneficiaries and you get a step up, why the heck not?
Can I emphasize one word you said? And I'm going to put it in capital letters and bold. If the power holder doesn't exercise it in a way that could be harmful.
Right.
Um, I think that it's really important to think before you leap. If Alan's approach of is correct, that the only way a fiduciary, the trustee, is going to be comfortable or safe doing this is to going to court and getting a court order. And if a court, and I could certainly see them doing it, requires some amount remain in the trust for the remainder beneficiaries, the cost and the complexity of that is going to dissuade many people from doing this. I think a lot of these questions are being asked by people who are not serving as trustee, and they're not thinking about the liability. Let me just give you, and then we'll go on to another topic, but let me just give you one thought that really concerns me. And I can't remember the statistics. I looked up the number, it was shocking. Um, um, the word used for it, I think, is not dating abuse, but romance fraud or something like that. I forgot the term of art, but it is not uncommon. It's shocking how much money has been stolen with romance scams. Maybe that's the phrase that's used. So, an elderly, and I've seen this happen to clients. I had an elderly widow many, it's several decades ago. This is not a new thing. And he was just, he had been married for over 50 years. He couldn't live alone. He was just devastated. and some bright sunflower caught his eye and gave him happiness and helped him heal his pain. And I think in less than 6 months after they were married, it was over, and she got half his estate. It happens, and the numbers. It was over $1 billion a year is lost in romance scams. If you have an elderly person and you're terminating assets and putting it in their name outside of a trust, you gotta be wary of that stuff. So again, I've seen a lot of questions about this. I have no idea how many people are actually doing it. I don't think we've terminated yet any trusts to get assets back in somebody's estate. Um, I'm not saying it shouldn't be done. I'm just saying you got to think through all the issues. And by the way, if you have the which I think is going to happen is some people are just going to ignore the trust terms, ignore everything else, and just pull the assets out and make the trust go away. That's risky to the trustee, and certainly the remainder beneficiaries. But I think you need at minimum to get people signed off as the remainder beneficiaries agreeing to the plan. But I think where that's going to run into an issue, we talked about the liability for the trustee. I'm worried, Alan, about the liability for us as the attorney. If those remainder beneficiaries don't have their own lawyer, right? How can you possibly represent them and let's say the elderly surviving spouse getting the credit shelter? You can't. And if everyone has to go out and hire their own lawyer, that still may be less than going to court, but it's not going to be inconsequential.
Right. Well, you're even though you don't, if you represent only the trustee and you don't represent the beneficiaries, you still have a duty to make sure that your client doesn't rip off the beneficiaries. And there are in most cities, I know in our city, there are 5 or 6 lawyers who are ad litems. They do a lot of ad litem work. And if I bring them something reasonable, they will approve it. And then I can go to the judge and ask the judge to appoint them. And that might cost $2,000 to $3,000. It's not a ton of money. It might take 6 to 12 weeks. It's not a ton of time to reduce liability and to make sure a family thinks through those things. And the other thing I'll say is on the power of appointment, it is a little dangerous. You're giving grandma a power of appointment. She's got dementia, maybe, and she can appoint assets to creditors of her estate. Some nurse has her sign a promissory note. There's a creditor of the estate. But on the other hand, the Treasury regulations specifically say it can be with it can be only exercisable with the consent of a non-adverse party. So then it's my next door neighbor has to approve any exercise of this power of appointment that I just gave my 92-year-old father-in-law. So the risk of problems is really almost zero, and the likelihood of getting a step up looks pretty good. So these are waters that we just have to step into. I mean, it's easy to say
Carefully.
carefully, carefully,
Yeah.
but put your life vest on, take your probate and trust litigator with you, and make sure that these families understand that these are opportunities. If they're educated and they do the right thing, they save a lot of taxes and they don't lose any family wealth,
They'll be very happy.
they'll be very happy.
Yeah.
Yep.
Apropos to your life vest, that's the key. Think through all the issues, and they're different for each client, right? Every circumstance is different. But if you can identify the issues and find a reasonable way that's acceptable to everyone to address it, that's fine. I think where the lawsuits are going to flurry, and I think they will, is where people do this without really thinking it through or don't look at the trust document. If the accountant or financial advisor doesn't speak to a lawyer and just has the assets pulled out of the trust and the trust doesn't permit that, that's bad. Got to be careful. And
Yeah.
you may be able to modify that, but you got to look at it.
Right. And don't let your clients borrow the money out at the applicable federal rate. That's not a fiduciary rate. The applicable federal rate is the lowest rate you can use without the IRS imputing interest. But just because it's okay for IRS purposes does not mean that it's okay for fiduciary purposes. You've got to pay a fair market value rental amount, a fair market value interest amount if you're letting the grantor enter into financial transactions with the trust. That will certainly be criticized otherwise.
Alan, um, one of the things we were going to chat about, which I also thought is a very powerful estate view mechanism, is to review an existing document. Is that something you're able to demo off the fly? And if so, I'll explain
Sure.
the concept.
Yeah.
So a lot of the AI estate planning software um, has capabilities to review a document and give you a summary and an analysis. I can tell you from experience with some, I won't name them in this context, programs, not this one, but I'm sure it's the same. You cannot accept a document summary from AI as gospel. You need to review the trust because there's fine nuances that could create estate inclusion, creditor issues. There's all sorts of things that you can't, AI is not for maybe a long time going to be able to evaluate every single issue in a trust. And it's not going to necessarily have input on all the relevant facts and circumstances, which you may understand as a professional. So, that being said, this is an incredibly powerful tool. So, I had a client come to me. I wanted to review existing trusts that parents had set up for him, and he didn't want to spend the money. His other advisors were saying these are irrevocable trusts. There's nothing to review. Mom and dad aren't changing them. And I said, look, first of all, if there's something really bad, and there is, I want to at least be able to tell the client so he knows. The way the trust was structured is on his death, it goes to his kids in trust. And at age, I think, 25, everything's outright to his kids. Why are you allocating GST? Why are you destroying asset protection? Huge issue. If he wants his parents to decant the trust and fix it, and they don't want to, that's fine. But now at least he's on notice. In the future, he can probably decant it and accomplish that protection for his kids. But the other piece, which the other advisors also missed, I said, even if we don't change anything in the trust and don't try to, if there's powers of appointment that my client can exercise, I got to know that even to do a basic will for him. Where's the money going on his death? What can he do with the power of appointment? So when you have a new client coming in, I can understand their hesitancy to want to have somebody spend time looking at a irrevocable document somebody else created. And this is just one example. But if you can feed it into AI and get a summary out of it, what a powerful way and how much does this cost to do and how much time does it take to ask AI to summarize a document?
Yeah. The cost to the subscriber is nothing.
There's
And
no incremental or variable cost. It's and Alan, I'm going to repeat something that we had talked about earlier in the context of the background check because I think it's important for people to understand that may not. I've tinkered. We have a subscription, and by the way, folks, if you're using AI, and everyone should be using AI, do not use a free version. Make sure you get a subscriber version so that it's not going to the cloud for machine learning. You don't want to put your client's document or facts into AI, even to ask a question and find out all this stuff is in the public domain. Bad. So I've put documents into AI and just asked asked it to summarize them or give me an analysis. And some of it was helpful. But the distinction, Alan, and I want you to explain it, is just like with the background check, you have spent a lot of time setting up a series, I don't know if it's 10, 20, 30 questions on the review of a trust to, if you will, train the AI to know what to look for. So you're getting something qualitatively better than what I can get just popping this into Chat GPT. Maybe before you show and illustrate what you've done, you should address that so people understand, because I'm not sure everyone understands the distinction.
yeah, we have about 40 pages of instructions that the AI is using, 40 pages of checklists and suggestions. And then it also has our favorite provisions. So when it looks at a spendthrift clause, when it looks at a trust protector provision, when it looks at an arbitration clause, it's also comparing it to our provisions. So it can explain how we might do it a little bit differently and looking for ambiguities and things like that. You know, AI is like a really, really talented teenager. It just doesn't do all of its homework. It rushes through things and it misses things. But that's the one advantage that software in the Amazon cloud has, that you can train the AI and it's slowing down. You can see it's much slower than if you were using ChatGPT, but it is methodically going through our 40 pages of instructions and and spotting the things that it's supposed to spot. And and I've not had hallucinations from this when it follows our instructions. It does a pretty good job. It saves a lot of time, Marty, because if I look at this before I look at the trust agreement,
Yes.
it saves a lot of time. It doesn't
Yes.
cost time, it saves time, but it always spots things that I, wouldn't have noticed or I wouldn't have thought of. So it gives you a really good checklist, and it's very client friendly. We just give it to the client. The client says, "Yeah, I was reading this. I think I understand it a little bit better now." And what's this? What's that? Maybe they have a better appreciation of all the things that we have to consider when we look at a trust agreement. So it's all
Alan, let me interject a comment because you said something and quickly went on, but I want people to understand the power of what you just said. Maybe you're so used to using this, you're forgetting how incredible it is. Client comes in, typical irrevocable trust, a sophisticated trust. If it's a decent size, if it's a decent practitioner, you're probably talking 50 to 100-page document potentially. We all sit down and read these trusts. But think about if you had a 5-page or 10-page summary in English of the trust before you start reading it. It's not just that you're more efficient, your eye is more likely to catch issues or important points because you have context. So you're getting a summary. You can't otherwise do that. Client comes to you from another law firm. You have 4 or 5 different trusts. What's going on? Where do you start? You could have to read 400 or 500 pages of documents to figure it out. But if you start with a summary, you have the big picture before you dive into the weeds. That's incredibly powerful.
right, right. And it'll even prepare a PowerPoint deck for the review and explanation of the client's estate plan, or a script that you could read. So it's very, very smart in the trust area. It's really amazing how smart artificial intelligence is when it comes to trust and estates.
Alan, when you have these instructions, do you have different instructions for different types of trusts? How do you do that?
I have instructions for each variety of trust. I will admit that even when it gets off track and off of my instructions, I'll go back in. Um, it, it's pretty darn smart. It is pretty darn smart the way it all works.
So would the AI summary pick up, for example, apropos to the client situation that I was facing, would it pick up whether or not there's powers of appointments given to my client as a beneficiary of this trust?
Absolutely, it would definitely pick up on that.
Do you have anything in what you have here to just show that?
Well, I can just ask it if you like.
Yeah, no, let's see. Let's see. So having powers of appointment, for example, and the example I gave my client, this particular client is the beneficiary of a pretty large trust. And I am sure that at some point, if not already, he and his wife's lifestyle is being impacted by the size of this trust. It just is so large relative to their current earnings and wealth that I can't imagine them not spending some of the money on the trust to maintain their lifestyle. So then the issue becomes if he dies, if the trust goes to his children, which is the typical scenario, descendants, his wife gets nothing. If there's a limited power of appointment where he can appoint even part of the trust to his wife, that would protect her financially by helping her maintain the lifestyle she has because of this trust while they're alive. And he could restrict it that if she remarries, it ends, etc. Whatever is done, I think it's vital to be able to point that out to a client. And if I could have said, because I wasn't using the summary at the time, if and maybe I should just do it and get back to him. But if I could have said, hey, it'll take me 5 minutes. We'll do it while we're on a Zoom meeting. I'm going to check this trust that you sent me, and we'll see if we can find anything in it. This is not perfect. This is not my review, but let's at least get a look at it.
Yep. So here's all the power of appointment review. It's got everything. It's really smart. the other thing that I really like that the programmers did for me is I can ask it to go ahead and do an amendment to somebody's trust to do the type things that I would normally want it to do. So just click on the items I want, click on generate amendment, and now it's preparing an amendment, which will include my favorite language in those areas to replace the language that's in there. So the client has an instant deliverable, and it saves some secretarial time as well.
Now, for an irrevocable trust, you'd have to then evaluate whether you can amend it. If not, you may have to decant it and change the administrative provisions, but that would be a starting point.
Yeah. And it automatically will tell me, oh, here's a trust protector. It recommends a trust protector action if a trust protectors are able to do it. If not, it can prepare a court action. So it's a good first draft just to get started with things. And there,
We all, I think it goes without saying, and I think everybody must feel this way. It's a lot easier to mark up and fix and correct an existing document than to sit down. We used to say with a blank piece of paper, but now it'd be a blank computer screen. Why not start with all these thoughts? And even if you catch things that are in error, look what you're starting with.
yeah.
Alan, make any other comments you want on this, and then we'll change gears for our fifth and final topic.
Well, let me just mention also, Marty, that when a client gives you a tax return, or their life insurance illustration or their life insurance policy, you can go ahead and click on the tax return. And I've got Elizabeth Warren's tax return here. And then it will tell me what her assets are and what her income is from each of those assets and what her deductions are and what expenses cause the deductions and what her maximum charitable donation could have been to be deductible that year. And it will tell me what her income tax planning ideas should be. So all I need is to input her tax return and all that just pops right out, which can be very impressive to the client.
I'm
And
very impressed that Elizabeth is your client.
I wish she was. She's got a lot of income. But when anything a client gives me, I can put in here. But for the
Well,
tax returns and especially the tax returns and the life insurance
what
information
does it do for life insurance, Alan?
for life insurance, it will read a life insurance policy or it will look at a life insurance illustration. So, and by the way, it's always going to base it on the state you're in. So it will critique the life insurance illustration and talk about the financial aspects of this permanent life policy.
It's interesting. I had a client the other day who had a policy, and the insurance agent brokerage firm is one that I've never enjoyed working with. I find them incredibly pompous and arrogant, and we have requested like 4 times from them an analysis of the policy and what they think of it and whether she should keep it or what options she has. And I think it's probably fine, but I'd like to know that we've looked at it because a colleague of mine is the trustee, and I think he needs to do that to protect himself in case there's ever a problem. And after the fourth request, I finally asked a friend who's an insurance consultant to look at it for me and tell me what's going on because I couldn't get the answer. Well, here I could have probably gotten something right away.
Yep.
And you haven't programmed in for this to be pompous and condescending, have you?
Right. Exactly.
We've all seen that. So Alan, let's change gears unless you want to say anything else and illustrate a plan. And when we're done, don't let me forget what I want to do is kind of wrap up and connect everything we've done from the standpoint of defensive practice, because we live in an incredibly litigious society. Estate planning, all professions, estate planning is a high risk profession. There's lots of claims, and I think with the transmission of wealth, as the boomers get older, it's only going to be more problematic. And everything we've done today, I think, are the kind of things that help make your practice safer for you. So let's go through one last illustration, and then we're going to connect all the dots.
Okay.
So
So,
let me just tee it up from a defensive practice perspective, and then I'll let you give the example. If you give a client one planning idea, and a client walks in, most of us as advisors, you not always, but in many cases, you know pretty quickly, listen, it's plan A or plan B that's going to be good for this person. But if you only give a client plan A and plan A doesn't work out, I'm concerned about heirs or the client or others pointing a finger saying, hey, why didn't you do plan B or plan C? So if you can efficiently, cost effectively, so you don't upset anyone, show multiple options for planning, and then the client with your guidance may choose plan A, they can't say you didn't give them A, B, C, D, and E. I think it's incredibly protective to offer options. Many of the malpractice cases, the issues were that impacts or the claims were that some of the impact of a particular plan wasn't explained or options that may have been better weren't offered. So, Alan, show me how we can do that
Okay.
quickly
All
and
right.
easily.
Sure. So what I've done is I just play from scratch to show you how easy it is. So I put the client's name down, and you may want to put an imaginary name down, even if you're going to show this to your client in case it leaks or in case they want to show it to other people. But a 65-year-old has a life expectancy of 20 years and a joint life expectancy between a 65-year-old and a 55-year-old. That's a 34-year life expectancy. It's good to know. Now, if they smoke, it's lower. So you can show that immediately. And then I gave them two children, so we can show some crummy powers. And then they're saving 500,000 a year until age 75. Then they'll be saving 150 a year, and they've got a $3 million home growing at 5% a year, a $3 million IRA growing at 7% a year. She has a $500,000 IRA, and then assets outside of the IRA. Let's say they have $35 million growing at 7.25%, 70% stocks, 30% bonds. And would they consider a charity on death? They would consider a charitable lead annuity trust. And then we can give them some life insurance. And if they're interested in life insurance, if Patty would like a $1 million policy, we could just give her $1 million policy. That tells me what it would cost, and we could put it in a life insurance trust. So that's how long it takes to set this up so that I can explain how the estate tax system may impact this client. So I click on Married Comprehensive, and I see that if they die in a year, they'll have a $5 million estate tax. But if they die and if they do all my planning, they won't have any estate tax if they die in a year. But if they do no planning and they live to 19 years and then 36 years for the second death, a, a $200 million estate plan, I mean, estate tax. Now, this is not artificial intelligence. This is all just custom programming. And it's taking what I think would be a good first draft estate plan based on the characterization. So then we show them a bypass trust, which gets the estate tax down a little. Then we show them a CUPERT for their home. And you see that this CUPERT takes a $3 million home and it ends up being a $17 million home with $17 million of rent that it received and reinvested.
Alan, just let me interject. It becomes 17 million because of the 5% growth over 19 years. I
Yep,
don't think most people imagine the impact of compounding.
right, right,
And what Alan's talking about, because he speaks fast, at the end of the Cupid term, you have a grant or trust hold the home for the kids, descendants, the kids, because it's not GST exempt, you can't because of ETIP allocate GST. But now mom and dad or whoever's alive has to pay rent to that trust to live in the home. And that's an additional transfer, which is what Alan pointed out.
right. That's right. And then it ran the
You're
number.
too fast, Alan.
Yep. So then it ran the assets. It ran the question of gifting 19,000 a year per child per parent. And look at this, after 19 years with 7.25% growth, that trust is worth 3,000,004 that passes estate tax free. 14.
Annual gifts are like the Rodney Dangerfield of planning because there's no sex appeal. It's not like a fancy complex trust, right? Or it could be in a trust. But people don't realize when you compound annual gifts, and if you have a handful of kids and another handful or two handfuls of grandkids, compound that out for 20 years, the numbers become wild.
Right. Yep. But then if they gift using discounts, using a 30% discount, using LLC interests, that gift trust will have, instead of 13 million or 14 million, it'll have 19 million nine. So that's why they should let us form an LLC and do annual gifting. And then with the life insurance trust, the estate tax goes from 162 to 163. The life insurance actually causes more estate tax because it reduces the gifting if you're going to be paying the premiums using crummy powers. But it does then show the life insurance. Then the next thing it shows is if they would make an $11 million gift this year and use a 30% discount, then that gifting trust would have $158 million in it after 36 years. That's pretty good performance. And get that
Well,
that
don't get excited because a milkshake at Mickey D's is going to cost what, about $10,000 at that point?
that's a good point. That's a good point.
We're not inflation adjusting. We're just showing, but inflation can really wreak havoc from a tax perspective.
Yep, yep, absolutely. So then we can mention rolling grats. If they just put $1 million into rolling grats, that would be 5,000,007 out of their estate over 36 years.
And
So
that's assuming you keep rolling every 2 years.
that assumes you keep rolling. So we could talk about rolling grats. Most clients would rather do an installment sale, but I want to I show a little one here so I can make sure I don't forget to talk about rolling grats. And then an installment sale to the grantor trust to explain how that might work. That got the estate tax down to 75 million. And then if they put the rest into a testamentary clat, they would have zero estate tax. The clat would get 188 million. And then the way we're showing it, their descendants would get another 75 million 20 years later. Now, this is just an instant plan. And what I can do at this point is I can, after talking with them briefly, I can change some of the scenarios. So I can say, yeah, they want to do the Cuperts, they want to do the annual gifting, but let's put more into the rolling grats. Let's put 50 million into the
Not
rolling.
yet. That's more than their estate, I think. I think you
Oh,
want to do five.
yeah, 5 million. Good point. 5 million into the rolling grats. And then the installment sale, let's go with 55% of their assets in the
I thought you were going to say a 55% discount. I want that appraiser's number.
yeah, but maybe a 35% discount. Then I just click on results again and click on married comprehensive again, come down here and see where that got us. So the rolling grats went from 5 million to 28 million. So maybe the rolling grats aren't so bad. And then the larger installment sale got that estate tax down lower to 41 million. And then what's left in the clat is 100 million with no estate tax. The kids get 457 million. So now what we do after that, Marty, just so you can see, is we click on save to calculators. And now we have all of our calculators that we use in more depth. Click save there, and then I can go to home and go to my married couple calculator, which gives me more details. And now there's all their data, there's all the planning techniques, there's all the different information. And what if they live in New York? So I select New York there. And now,
Alan, let's not go deeper because I think it's important to talk about what you've done. I have a different view I want to talk about from a defensive practice perspective, which is how I led into this. But why don't you talk from a practitioner's perspective, how this helps you at a meeting with a client to explain and illustrate what's really going on. And then I'm going to come back to defensive practice and we'll try to connect all our topics with that.
the clients and the advisors that you're working with are able to understand the estate tax system when they see the numbers. They're able to understand. It's not that hard to understand that here's what you have today. Here's what you're going to have in 19 years based on some reasonable assumptions. Here's what you're going to have in 36 years. And here's what the New York and the federal government are going to take from your children if you do no planning. I mean, it does not take a mathematician or a great expert to understand that if you do the Cuperts and you do the annual gifting, this is lower. And if you do a large gift, it's even lower. I mean, that's something that somebody without a lot of education is able to understand. They're able to understand what actually they can understand what that New York Q-tip trust is, what the bypass trust is, what the Cupert will grow to, what the annual gifting will do. So it makes it understandable to them, Marty. But I think what's just as important is I used to think that I knew what would work and what wouldn't work in an estate plan. I used to think, well, the big gift must be better than the installment sale. It just feels like it is. But now I can run the numbers.
It's not always intuitive.
It's not always intuitive.
And I think one of the big risks to the intuitive plan is anytime you roll something out 20, 30 years, the numbers become very different and changing assumptions. So if I were to look at this, I said, maybe I'm not going to get a 7% return on my portfolio. I'm older. I'm really a 50-50 allocation. Why don't you make that 5.5%? You click, and you change the number and you look at it. But even with that, for a lot of people, bam, it's still a big number that they need to plan.
Right, right. And you're right, you have to run it at 5%, but you also have to run it at 10% because there's
Yes.
as much chance that it's going to be 10%. So, you could turn off, they could say, well, I'm not going to do the large gift. I'm going to do an installment sale as big as I can, and then go down to the installment sale and just uh, make the installment sale as large as you can just by cranking up the installment sale number. So
So if the client has a question like, hey, I'm doing much better on my portfolio, I'm confident I'm going to do that for the long term, you change the return on that.
that's right.
And the client may say, listen, real estate, unless you get lucky, it doesn't grow nearly that fast. Make that 3%. That's probably could be for many people more reasonable, but
That's right.
you could just change those assumptions.
That's right. Yeah,
So it's really an interactive way that you can demonstrate and evaluate planning options. So,
exactly.
Alan, let me raise the defensive practice comment that I introduced this with, and then I want to try to connect the dots of the five topics we've talked about. I think practicing defensively is unfortunately critical for all of us in every profession that does estate planning. It just, I always joke that, every kid thinks they're going to inherit 150% of whatever mom has. And we all have seen lots of prospective errors with that attitude. Um, if you simply did, and what Alan said is what traditionally has been done and still is done, and I think that just anecdotal, my thought, the vast majority of estate plans, the practitioner doing the plan feels that the C plan or the J plan is the right plan. And we all know practitioners that are like 2, 3 trick ponies, and they have a couple of plans and they pick one for each client and they got their standard forms and bam, they bang it out. What this is showing to me is that I can sit down with limited input time and demonstrate to a client, here's 5, 6 different approaches to the plan. And because I can vary the input, if you think your family business is growing at 16% a year, we can do that. So now when a client comes back and, plan C and plan J are picked and everything else is excluded, you have in your file the information showing that you discussed with the client 6, 8, 10 different plans. I think that's incredibly protective because ultimately it has to be the client making the choice. But if you're not giving them a choice, what's happening? I try very hard when I do a memo for a client to always mention planning ideas that we're not using. Say, if you want to discuss these further, we can. I don't want some, especially an heir coming back and saying, hey, why didn't you do this plan? Because the one thing the heir gets that we don't get, Alan, is what? Hindsight, right? We can only plan what we know today. But 20 years from now, if it doesn't work out well, the heir knows what the result is. So showing, look, we looked at all these different factors. We could have changed any input or variable. I think this is a huge step forward in defensive practice for the practitioner. Alan focused, rightfully so, on wow, I can do a better job for my clients and I don't have to just guess. I can actually see what things look at and show them. That's powerful. But to me, defensive practice is very important for us. And as lawyers, unlike accountants and financial advisors and appraisers, can we limit our liability with a client, Alan?
Nope.
Nope. Alan used to have a tie and jacket, but
They were taken away from
they
me.
were taken away.
The other thing, Marty, is with the illustrations, I can share the illustrations and I can share the use of the software with the investment advisor, with the CPA,
Let them tinker.
advisor, and everybody can collaborate. So it's not just me, it's
It's interesting.
everybody working together.
Can you keep your inputs frozen so you always have those so you know what you have a record of?
Mm-hmm. Yeah.
Very,
Plus,
I didn't know that. That's very powerful.
and it creates an explanation letter to the client, which shows all the inputs and shows the outputs. And I can create three explanation letters, one at 5%, one at 8%, one at 11%. I can send the software to the client and let them play with it. And a lot of these clients who are engineers and CPAs and MBAs, and if you're 16-year-old or younger, you can understand how to use this software pretty easily.
Let me try to connect the dots of our five topics from a defensive practice perspective, and then I'll let you wrap up and we'll conclude. We talked about a self-settled trust case, adapt case in Delaware. I think it's still good law. It doesn't solve every issue. It didn't address the full faith and credit, but it was very powerful. The fact that the guy lost out in Colorado, what he did really didn't seem to make any sense the way I'm reading the case, and it was just a bad deed, and it got addressed. Credit shelter trusts, other irrevocable trusts, lots of clients are going to terminate them. You got to think it through and you got to look at it because the liability exposure to the trustee, to the practitioner advising could be bad. Background checks to me is a very powerful way to weed out. We don't get a lot of bad people, but they do come in. And boy, if you could ferret them out before they become a client, you got no issue saying, you know what, we don't have the capacity to help you right now. We're too busy. Um, a document review, even if you haven't gone through it, at least it's a starting point. It makes you much more efficient. But as Alan said, it's going to pick up stuff that maybe you didn't catch. What a powerful thing to take advantage of. And the planning that we just illustrated, what a powerful way to protect yourself by saying, Your Honor, we gave the family at least a half a dozen different options. And as Alan just pointed out, a memo summarizing them. So I think adopting technology, not letting our guard down with like the trust termination, staying on top of developments like this asset protection case, I think are great ways to really help us grow our practices and do better work and in a safer way. Alan, I'll let you take the final word.
I think you said it all, but it can be very enjoyable to do a better job and to do a more thorough job in actually less time and to have the clients understand and appreciate what we're doing. So it is a nice opportunity that we have here with the technology.
I think it takes, you have to adapt to it. And it's always hard to adapt. But there's a phrase, there's no growth in the safe zone or in the comfort zone, and there's no comfort in the growth zone. It's uncomfortable delving into stuff that's so new, but that's how we grow as practitioners, professionals. That's how we grow our practices. So I wish everybody good luck. Alan, thank you for, I had fun. I hope everyone else does. Be well,
Absolutely.
everybody.
Thanks,
Thank
Mark.
you.